A very warm welcome to our chief guest, Honorable Mr. Justice Rajesh Tandon, former Judge, High Court of Uttarakhand. Guest of honor, Advocate General of Uttarakhand, S.N. Babulkar, our special guest, author of the Moot problem, and her associate author, Mr. Anush Tiwari, Professor Dr. Tapan Kumar Chandula, Dean, ICFAI Law School, Dehradun, Faculty Convener, Dr. Sudhir Kumar, and our Faculty Co-Convener, Mr. Abhishek Kukreti, all our respected faculty members, and all our dear participants. Before commencing our event, I request Professor Dr. Tapan Kumar Chandula sir to kindly felicitate our chief guest, Mr. Honorable Justice Rajesh Tandon sir with memento and shawl as a token of gratitude and respect. Now, I request Dean sir to kindly felicitate our guest of honor, Mr. S.N. Babulkar sir with memento to express our gratitude. Now, I request Dean sir and Sunil sir to felicitate Mr. Anush Tiwari, our special guest for the event.
हमेशा याददाश्त वाली साझेदार नाम से लोग
Thank you so much, sir. To complete our quorum for the finals of the 5th ICFAI National Moot Court Competition 2024, I request Professor Dr. B. Acharya and Professor Dr. Arun Kumar Sen to kindly join our judges.
A very good morning to the honorable judges and all the participants presenting before me. It's my pleasure to welcome you all on the behalf of ICFAI University to the 5th ICFAI National Moot Court Competition 2024. If it may please your lordship, I would like to enlighten the participants with If it may please your lordship, I would like to enlighten the participants with few rules and regulations and the time bifurcation of both the leaves. Much obliged, your lordship. Placards will be shown in the remaining 5, 3, 2 minutes and 30 seconds will be level. It is the responsibility of your participants to see the placards. No misbehavior will be entertained. Extra time will be allotted only on the sole discretion of the honorable judges. Breach of any of these rules may lead to the disqualification. I hope I am clear with the rules and regulations. Now it's time for telling you time allocation. C02, petitioner takes 12.5 minutes. Speaker 2, 12. I'm sorry. TC02, respondent, speaker 1, 12.5 minutes. Speaker 2, 12.5 minutes. And TC21, speaker 1, 12.5 minutes. Speaker 2, 12.5 minutes. 5 minutes is allotted for rebuttal and side rebuttals. If your lordship permits, the court may start with the proceedings.
Yes.
Much obliged, lordship. The court is now in session.
Council takes permission to approach the live. The council takes permission to address the bench collectively as your lordship. Much obliged, your lordship. It is indeed a matter of great pride and honor to stand before the Honorable Supreme Court of Arundel in the matter of Mr. Ashok and Ms. Anita Kumar versus Union of Arundel. Your lordship's counsel will be dealing with issue number 1 that relates to the maintainability of writ petition and issue number 2 that relates to the arrest of Mr. Ashok. The co-counsel will be dealing with issue number 3 and 4. Before proceeding further, the council humbly seeks the permission of the honorable bench to iterate the facts and circumstances that led to the present. Much obliged. Your lordship, in June 2019, Mr. Ashok Kumar and Mr. Ajay Kumar met. Mr. Ashok Kumar presented himself as a business facilitator, basically a facilitator of business financing. He showed an authority letter of HDFC Bank, which basically provided the proof that he was a loan agent of the said bank. Mr. Ashok told Mr. Ajay that he would apply a loan of 100 crores for him, and for that very purpose, Mr. Ashok Kumar and Mr. Ajay Kumar once again met at a hotel in Vanya Vihar Kshetra on 26 June 2020 for approving the said loan of 100 crores. Mr. Ajay Kumar in this case provided post-dated security check and draft documents signed by him for sanctioning and acquiring the particular loan from Mr. Ashok. On 28 June 2021, your lordship, rupees 1 crore 50 lakhs was debited from the account of Mr. Ajay and deposited in the account of Mr. Ashok. 1 crore was deposited in the account of Mr. Ashok and 50 lakhs was deposited in the account of his sister, Ms. Anita. Based on the above facts, an FIR was registered by Mr. Ajay at Kshetra in Vanya Vihar on 29 June 2021. The Enforcement Directorate in this particular case registered an ECIR on 26 July 2022. The ED began its investigation, and in the conclusion of the investigation, the Assistant Director of ED arrested Mr. Ashok on 2nd of October 2023. Mr. Ashok, at the time of his arrest, was informed of the grounds of his arrest. However, only orally. The grounds of his arrest are as follows: that the Assistant Director had reason to believe that Mr. Ashok was guilty of an offence under Section 3 and 4 of the Prevention of Money Laundering Act, that bank statements of Ashok and Anita show an unexplained credit of rupees 4.5 crore, that Ashok had been uncooperative and evasive during the investigation conducted by the ED under Section 50, and also that Ashok had diverted all the money by withdrawing the cash, which could not be traced by the ED. On 2nd of October 2023, Ms. Anita was also issued summons by the ED under Section 50 to appear as a witness at before the ED. The Director of ED also attached a land parcel domicile owned by Mr. Ashok and Ms. Anita, which was acquired by them on 23rd of March 2020. The present writ petition is filed by the petitioners in this case, challenging the arrest of Mr. Ashok, issuance of summons to Ms. Anita, and the attachment of property by the ED. If your lordships are well versed with the facts of the case, the council takes permission to move forward with the statement of jurisdiction.
You have filed the SLP, not writ petition.
Your lordship, in the present case, the petitioners have filed a writ petition under Article 32 for a legal and arbitral claim.
It is called SLP. Supreme Court petition.
Your Lordship, SLP, in this case, SLP stands for Special Leave Petition, Your Lordship. In the present case, it's a writ petition, it is not an SLP.
Actually, why have we not approached the jurisdictional high court under 226?
Thank you so much for your question, Your Lordship. The petitioners here have faced a grave violation of fundamental rights due to illegal arrest under Article 21 of the Constitution, and we have the right to directly approach the Supreme Court under Article 32, Your Lordship.
But we have to approach to honorable high court of the judge.
Indeed, Your Lordship, that is an alternative remedy. However, in the present case, if there has been a gross violation of the fundamental rights, the same will be substantiated in the further arguments of the council in the forwarding issue. Because of such violation, the petitioners have a motive standard to directly approach the Supreme Court under Article 32.
Are high courts not empowered to deal with gross violation of fundamental rights?
Your Lordship, the High Courts have the power under Article 226 of the Constitution of Ireland. However, since
Why do burden us? Go to jurisdictional high court.
Your Lordship, since again it is being contended by the council that it is a case of illegal and arbitrary arrest and a gross violation of fundamental rights, the council would be humbly pleased if the Supreme Court would admit the petition.
It is a relief under Article 226.
Indeed, Your Lordship, there is a limit under Article 226. However, the council believes that the Supreme Court here should admit the petition because it is a violation of fundamental rights, and the enforcement of fundamental rights is the Supreme Court is the protector and guarantor of fundamental rights. Your Lordship, that is why the petition should be made.
Of similar issue in other cases?
Pardon, Your Lordship?
Are we seen of similar issue in other cases?
Your Lordship, the Supreme Court has upheld the very fact that when there is a gross violation of fundamental rights, the petition shall stand maintainable and there is a taken.
Recently, in several matters, the Supreme Court has said that go first 226 and then Article 32. And why you have not adopted that practice also, we go to High Court, then Supreme Court.
Indeed, Your Lordship, the council does agree with that. However, this court itself has held in Rovila Thakur, in the case of Rovila Thakur, the Supreme Court is the protector and guarantor of fundamental rights. When there is a gross violation of fundamental rights, the Supreme Court is left with no discretion to issue writs that may provide a remedy to the petitioner.
Fundamental rights of yours, these on these facts, which fundamental rights?
Your Lordship, the petitioner is specifically contending a violation of Article 21 under the Constitution of Ireland. The same will be substantiated in the further arguments if the council may not be.
How 31 is applicable, how 31 comes into play, all these facts.
Indeed, Your Lordship, the Article 21 comes into play when the illegal and arbitrary arrest of Mr. Ashok came into picture due to the violation of procedure established within PMLA. The same will be dealt in the issue number 2 specifically, Your Lordship.
Sir, private law remedies as well.
Pardon, Your Lordship?
Private law remedies as well. You can go for bail, you can go for anticipatory bail, you can go for arrest stay. Why you have to straight away jump to the Supreme Court?
Your Lordship, in this particular case, because Mr. Ashok has been arrested by the Assistant Director of Media, and there has been procedure violation. Additionally, because he has not been produced before the magistrate within 24 hours of his arrest, the council is furthering a petition of habeas corpus to basically demand his protection and his.
Council must be aware of where. And regardless of fact, I think public law remedies are always based on this, that where there is a right, there is a remedy. Unless and until you show that there is clear-cut violation of your fundamental right, you cannot straight away go to the High Court or to back to the Supreme Court. How is violated Article 21 comes into play? On these facts, it is a purely private transaction. You are dealing with somebody as regards of money or something else.
Was there any violation of section 19 of the Money Laundering Act?
Indeed, Your Lordship.
Yes, was there any violation? If the violation is there, then you can say that you have the right to go under Article 32. But
Indeed, Your Lordship. The council further arguments from the state that there has been a violation of the procedure prescribed under section 19, specifically subsection 1 of the PMLA Act, wherein it states that reason to believe form the grounds for arrest, and such reasons to believe must be recorded by the officers of PD before an arrest is effected under the same section. Your Lordship.
Read the Ram Nation Arora case.
Indeed, Your Lordship. Indeed, Your Lordship.
Let's say on recording of reason of arrest.
Your Lordship, the Ramkishore Arora case states that reasons must be recorded in writing and the reasons also have also been communicated to the person directed in, person being directed under section.
So say that even if it is communicated orally, then also it will comply with section 19.
Your Lordship, the council in the present case is drawing inference from Pankaj Bansal, which is also a Supreme Court judgment, and the council here contends that
Does R.K. Arora case deal with Pankaj Bansal case?
Your Lordship, the R.K. Arora case is an extension of the Pankaj Bansal case where the law has been elaborated
How does
upon.
it deal with Pankaj Bansal case?
Your Lordship, Pankaj Bansal case, if your Lordship could kindly refer to page number 22, paragraph 9 of Pankaj Bansal
Does
case.
Pankaj Bansal uses the word henceforth?
Indeed, your Lordship, it does.
Before the arrest made?
Arrest was
Before
made.
Pankaj Bansal or post Pankaj Bansal?
Arrest was made just a day later on 2nd of October, just a day before the Pankaj Bansal judgment
Pankaj
came.
Bansal applied to you.
Your Lordship, the council here contends that Pankaj Bansal will be applicable retrospectively. The council places reliance for the same on the case of Assistant Commissioner for Maharashtra Touch Stock Exchange Limited. If your Lordship could kindly take note of paragraph 35.
Whether Pankaj Bansal will apply retrospectively.
Indeed, your Lordship, the council contends that here.
So what does R.K. Arora say about Pankaj Bansal? Will it apply retrospectively?
Your Lordships, the R.K. Arora case does say that the Pankaj Bansal case is not applicable retrospectively. However, drawing inference from other judgments, the council condemns that it will be applicable in the present case and the other threshold. Pardon me, Lordship?
Binding on us.
Your Lordships, R.K. Arora holds persuasive value before the honorable bench.
But Pankaj Bansal has been released by the Supreme Court only on the ground that the 19 has not been followed.
Indeed, your Lordship.
Yes, and he has been also released on every proceedings have been request.
Indeed, your Lordship. Pankaj Bansal laid down three very important principles while effecting arrest under section 90. That is, grounds of arrest must be provided to the accused person in writing when an arrest is being carried out under section 90, subsection 1 of the amendment. Additionally, also that non-cooperation and evasive response cannot form a ground for arrest for effecting an arrest under section 90, as well as that the arrest cannot be carried out on malified grounds. If the Lordships could kindly take note of page 22 of the compendium filed by the respondent, paragraph
How should
9.
deal with the next issue?
Much obliged, Your Lordship.
But time is very short for you.
Indeed, Your Lordship, the council has provided arguments for the second issue itself, where the question stated that there is clear violation of fundamental rights of Mr. Ashok because the grounds of arrest have not been provided to Mr. Ashok in the present case. They have only been informed to Mr. Ashok. If Your Lordship could kindly take note of paragraph 9 of the Moot proposition. The council brought inference from recent Balaji, where this has been stated that grounds of arrest must be informed to the accused person, and it is a constitutional safeguard under Article 22 of the Constitution of Ireland, Your Lordship. No person can be detained without informing the grounds of his arrest.
But grounds have been informed.
Your Lordship, drawing inference once again from Pankaj Bansal, the Supreme Court itself has stated the grounds must be communicated in writing to the accused.
Henceforth.
Indeed, Your Lordship, the council once again humbly contends that Pankaj Bansal in this case will be applicable and will also be applicable retrospectively. Your Lordship could kindly take note of the case of Assistant Commissioner of Maharashtra Touch Stock Exchange Limited, paragraph 39 of page 4 of the
Bansal
complaint.
case of Punjab and Haryana High Court.
Pardon, Your Lordship.
And you read the Moot Bansal case of Punjab and Haryana High Court.
The council is not aware of the same, but may get back to Your Lordship at a later point in time. The council humbly seeks an extension of 2 minutes to summarize the arguments.
Because two decisions are encyclopedia, that is Arora and Pankaj Bansal. They are the encyclopedia. Every case has been dealt with.
Indeed, Your Lordship.
Yes, next.
We'll hear the next one.
Much obliged.
The council should conclude the last.
First state the brief facts.
Your Lordship, the facts are as follows. As read, I will be reiterating the facts. The facts are as follows, that the accused in the present case, Mr. Ashok, he was accused of the offense of cheating. The victim was Mr. Ajit, and amount of rupees 1.5 crore was transferred from Ajit's bank account to Mr. Ashok's bank account, and Ms. Anita Kumar, who is sister of Mr. Mr. Ashok Kumar. But then there that was the amount of 1.5 crore was transferred, and on the basis of that, Mr. Ajit filed the FIR at collection, and a year later, ED filed the ECIR in the same matter. And after that, the ED summoned Mr. Ashok and questioned him. And on the ground of non-cooperation with the ED during the investigation process, they arrested him and provided other grounds of arrest, and then later issued summons to Ms. Anita on the same day for coming at the inquest office of ED, Your Lordship, and later attached the property jointly owned by Mr. Ashok and Ms. Anita. If the Lordship was satisfied with the facts of the case, the council needs to move forward with the submission of official.
Yes, yes.
Much obliged, Your Lordship. The council shall establish that the summons issued to Ms. Anita Kumar is not in accordance with law. The argument shall be presented to Your Lordship in a two-pronged approach. With regards to the first prong, Your Lordship, Section 65 of PMLA clearly states that the provisions of CRBC will be applicable to PMLA in matters related to arrest, search and seizure, attachment, investigation, and all other proceedings under this Act. Your Lordships, Section 50 of PMLA clearly provides the power to ED officers to summon any person they consider necessary. However, Section 50 only provides the power, not the procedure, Your Lordship. And no procedure is also provided either by central government or PMLA rules. Therefore, in the absence of any provision regarding investigation or inquiry under the Special Act, provisions of CRTC, which is the General Code, shall be applicable, as has been upheld in the case of Asmita Agrawal versus Enforcement Directorate.
Is there a provision in PMLA which says that CRPC will apply?
Yes, Your Lordship. Section 65.
Is there a provision in CRPC which says that CRPC will also apply to special law?
Indeed, Your Lordship. Section 4 of CRPC.
That has also been mentioned in the Pankaj Bansal case.
Indeed, Your Lordship. Moving on.
The reference of 167 has been given. Of CRPC.
Indeed, Your Lordship. Section 167 in under the present case, under the Act for the argument is not relevant in our counsel is arguing on the basis of the Section 15, Section 160 of CRPC, Your Lordship. The counsel needs to move forward. Much obliged, Your Lordship. In the case of Asmita Agrawal versus Enforcement Directorate, Your Lordships may refer to page number 43 of the complaint. Para 7. Indeed, Your Lordship. Para is the number. Indeed, Your Lordship. Section.
The Abhishek Banerjee judgment of Delhi High Court.
Indeed, Your Lordship.
It on PMLA.
Yes, Your Lordship. No, Your Lordship, the facts present, the ratio of the Abhishek Banerjee is irrelevant under the present arguments, since it has been stated by the Supreme Court under special leave petition, as has been stated in the judgment of Malloy Order. Your Lordships may refer to page 46 of the complaint, where it is clearly stated that the judgment of Abhishek Banerjee has been stayed by Supreme Court. The
division bench judgment of Madras High Court in Delhi Chitambram.
Indeed, Your Lordship, even Nalini Chidambaram versus Madras High Court judgment has been stayed by Supreme Court in the same paragraph. The Lordships may refer to page 46 of the complaint. The counsel please to move forward. Much obliged, Your Lordship. In the case of Congress versus Union of India, Your Lordships may refer to page 45 of the compendium, para 43, where it is clearly stated by the court that Section 160 of CRPC is not inconsistent with Section 50 of PMLA and can be applicable on the said Act. And by virtue of that judgment,
How will you deal with Section 71 of PMLA?
Your Lordship, Section 71 of PMLA states that any statute that is inconsistent with CRPC, inconsistent with the PMLA, shall not be applicable. PMLA shall prevail, Your Lordship. However, in the judgment that the council has cited, that is 4 years, the court itself has gone into the detail and held that Section 160 of CRPC is applicable and is not inconsistent with Section 50 of PMLA.
Para 458 of Vijay Madan Lal Chaudhary.
In Your Lordship, the council do not have the exact.
Vijay Madan Lal Chaudhary says that Chapter 12 will not apply to PMLA. Right, well,
Your Lordship, when it comes to the issue of summons, Vijayanagar only discusses it in the context of self-incrimination, and no other grounds have been discussed in the said judgment, Your Lordship. The council needs to move forward. Much obliged, Your Lordship.
Next point.
Your Lordship, the present, the council would like to bring your attention to the facts of the case. The provision 1 of section 160 of CRPC provides a safeguard to women that they should not be summoned at the police station. Rather, they should always be examined at their place of residence. However, in the present case, Your Lordship may refer to para 10 of the Moot proposition, where it is clearly stated that Ms. Anita Kumar is a resident of Kalishekar. However, she is summoned by ED officers at their office in the present, which is a procedural violation. And on the ground of such procedural violation, the summoning order issued by ED is arbitrary. If the councils are satisfied with the first prong of the argument, the council will need to move forward with the second prong of the argument, Your Lordship.
read section 50.
Indeed, Your Lordship.
Section 50 clause.
Indeed, Your Lordship. Section 50 clause 2 specifically provides power to the ED officers to summon any person they consider necessary for the purpose of effective investigation.
Does it say any person?
Indeed, Your Lordship.
Whether women will be included in any person?
Indeed, Your Lordship.
Men will be included in any person?
Your Lordship, women can be included in any person. However, it is only the power. Your Lordship, the council is arguing on in regards to the procedure of the act. It is only the power. Procedure is being will be governed by section 160 of CRPC, Your Lordship, in the present case, as has been upheld in the case of policy garden, as the council has cited already. The council needs to move forward with the second prong of the argument. Your Lordship, the council once again would like to bring your attention to section 50, subsection 2, which provides the council would like to read the Bail Act. Your Lordship, section 50, subsection 2 says the director, additional director, joint director, deputy director, or assistant director shall have the power to summon any person whose attendance he considers necessary. Your Lordship, the word consider can be interpreted as careful thinking or due application of mind, which is a sign to a norm for issuing summons order, as has been upheld by Supreme Court in the case of Valium Chemicals versus A.J. Rana. Your Lordship may refer to page 50 of compendium. The council pleads to move forward. Much obliged.
You say he has not applied his mind?
Your Lordship, the procedural version that has been done by ED officers under the section by violating the grounds given, safeguards given in the section 160 of CRPC. And due to procedural violation, it can be said that the due application of mind has not been exercised by ED officers. Therefore, which is the ground to challenge the exercise of administrative discretion. Hence,
Money transfer into your account.
Your Lordship, the council will deal with the said matter in the issue, that is the issue number 4. The council needs to move forward. And with regards to the submissions of issues, the council humbly submits that the summoning order issued by EDs are arbitrary in nature, Your Lordship.
Unidentified money.
Your Lordship, the council will deal with this with the setback under issue 4. The council needs to move forward. Much obliged, Your Lordship. The council will establish that the attachment.
Argument is this, that there had been a breach of procedure,
Indeed, Your Lordship.
but can't exercise incidental and consequential powers.
Your Lordship, the council will provide you more clarity regarding this question at a later point of time.
Very deviates from the procedure. You mean that when a law requires a thing to be done in a particular manner, that has to be done in that manner and not alone and not otherwise.
Indeed, Your Lordship.
This is the general.
Indeed, Your Lordship.
People is a good servant, but bad dangerous master. Sometimes an officer who is exercising power, he has to exercise his incidental consequential power in order to make the exercise of power very effective and perfect. Then in that situation, can we say if there is a breach of procedure?
Indeed, Your Lordship. However, here in the present case, since there has been procedural violations, can be said that due application of mind has not been exercised by the ED officers, which is a violation of the administrative discretion that has been provided to them. Your Lordship, the council pleads to move forward with the submissions of issue 4. The argument shall be presented to you in a two-pronged approach. With regards to the first from your lordship, the council would like to bring your attention to the definition of proceeds of crime given under section 2, subsection 1, clause U of PMLA. For the convenience of the bench, the definition of proceeds of crime has been divided under 3 heads. Under the first head, proceeds of crime refers to any property derived directly or indirectly by any person as a result of criminal activity related to the scheduled offences. Under the second head, value of such property derived from the scheduled offences. And under the third head, where such property is held outside the country, property equivalent in value can be held within the country. Your lordships, only those properties which appear to be proceeds of crime can be attached, not all property. The council would like to give attention to the facts of the case. The property was acquired prior to the commission of schedule. The land parcel jointly owned by Mr. Ashok Kumar and Sita Kumar was acquired prior to the commission of scheduled offences. And in the case of Abdullah Ali Balsaraf versus ED, which is a 2019 case of Delhi High Court, as has been cited under the page 53 of Compendium Lordship and page 15 of the additional Compendium. Your Lordship may refer to paragraph number 109. It is clearly stated that any property acquired before the commission of scheduled offences cannot be attached or cannot be considered to be proceeds of crime, Your Lordship.
Have you read the proviso of section 5 PMLA?
Yes, Your Lordship. The council will address this issue under the second prong of the argument, Your Lordship. The council needs to move forward. Much obliged, Your Lordship. Section, the said section, that is section 5, which provides the ED the power to provisionally attach property. The exception of this is the general rule that the property of equivalent in value can be attached when the proceeds of crime has been taken outside the country. However, Your Lordship, in the present case, there is no material facts given in the presented before us which shows that the proceeds of crime has been taken outside the boundary of the country. Therefore, the bank statements that have been attached as a property of equivalent in value cannot be attached under the present circumstances. Therefore, the council seeks the extension of 2 minutes for summarizing their arguments. Much obliged, Lordship. Under the second prong of the argument, section 5 subsection 1 clearly states certain essentials that needs to be followed by ED officers. The first one being there needs to be material possession. The second, on the basis of such material possession, there needs to be reason to believe. And this reason to believe needs to be recorded in writing, Your Lordship. Under the case of J. Segar versus Union of India, it has been clearly stated that reason to believe needs to be in writing. And if it is not recorded in writing, it is not a mere procedural irregularity, it is an illegality. Your Lordship, under the present circumstances, there is no mention that the ED officer has recorded the reasons to believe in writing. And therefore, the council submits that the order of attachment that has failed to fulfill the conditions under section 5 subsection 1 amounts to unfettered discretion on the part of ED and vitiates the legality of the order of provisional attachment. Therefore, such order is liable to be set aside. Your Lordship, the council submits the submissions of issue 4 and please to move forward for deciding the favor. Much obliged, Your Lordship. Therefore, in the light of issue raised,
You have not demonstrated about 226, the difference of 226 and 30.
Your Lordship, section 226 deals with the power of High Court and section 32 the power of Supreme Court with regards to the violation of fundamental right. Your Lordship, the council please to move forward with the submission of prayer. Decided of prayer, Your Lordship.
Where she has to go is 32 or 26.
Your Lordship, the power of the Supreme Court in the under Article 30.
32.
Yes, Your Lordship. Much obliged, Your Lordship. The council needs to move forward with deciding the prayer. Therefore, in the light of issue raised, arguments advanced, reasons given, authorities cited, it is most humbly prayed before the Honorable Supreme Court of Ireland that may be pleased to order the release of Mr. Ashok by setting aside the order of arrest under section 19, subsection 1 of PMLA 2002, quash the order for summons issued to Ms. Anita Kumar under section 50, subsection 2 and subsection 3 of PMLA 2002, and declare the provisional attachment of property under section 5, section 1 as null and void, and or pass any order, relief or direction. that the Honorable Court may deal with in the interest of justice, equity, and good conscience, all of which is respectfully submitted, and for this act of kindness, the petitioners here will be bound shall ever pay. It was a pleasure arguing before the Honorable Bench. Much obliged, Your Lordship.
Does the speaker have permission to approach the podium? Speaking to the day, does the speaker have permission to refer to the judges individually as your lordship and collectively as your lordships? Much obliged. In the matter pertaining before the Honorable Supreme Court today, the counsel for the respondent shall be represented by me as Speaker 1 and my co-counsel as Speaker 2. My co-counsel shall be dealing with issues 1 and 4, that is the issue of maintainability as well as the attachment of the assets of the petitioner. And I shall be dealing with issues 2 and 3 pertaining to the arrest of Mr. Ashok and the subsequent issuance of summons to Mrs. Anita and his sister. Would your lordships want to be apprised of the facts of the present matter?
The attachment power is under the act itself.
Indeed, your lordship. Would your lordships want to be apprised of the facts of the present matter?
Yes.
Indeed, much obliged, your lordship. The facts of the present matter can be given in the form of a very simple timeline, your lordship. Firstly, in June 2019, Mr. Ashok met Mr. Ajit. Mr. Ajit is the complainant in the FIR in this particular matter. Both of them met, and Mr. Ashok presented himself to be a businessman and a loan agent. And for this purpose, he also showed an authority letter. He said that he was a loan agent of several banks, and he showed one particular bank's document to prove that he was a loan agent for their particular banks. Furthermore, in March 2020, Ashok showed him other documents pertaining to subsequent sales that he had done previously in order to further bolster his claim of being a loan agent. Thirdly, when it comes to 28th of March 2020, that is when Ashok and his sister had purchased a property of land that is worth 90 lakh rupees. Next, when it comes to June 26, 2020, that is when Ashok and Ajit again met in a hotel in Danish Vihar, and that is when Mr. Ashok told Mr. Ajit that he would get a loan of 100 crore for him, and for that he would need signatures on land checks and land documents because the financiers had those particular needs. And Mr. Ajit signed those documents and gave them to Mr. Ashok. Furthermore, on 28th June of 2021, that is the day when 1.5 crores was debited from Mr. Ajit's account, out of which 1 crore was credited to Mr. Ashok's account and 50 lakhs to Miss Anita's account. Based on this, on 29th June, the very next day, the FIR was registered at the police station in Kalachirpur. And a year later, that is 26 July 2022, the ECIR was registered by the personal director.
Where was ECI registered also?
The ECIR was registered in Indraprastha, Your Lordship.
Do you have jurisdiction to register ECIR in the first?
Your Lordship, the Enforcement Directorate has a pan-India jurisdiction, and therefore, since it's not a statutory bar when it comes to territory limitations that are posed under the PMLA Act, therefore the jurisdiction is pan-India.
Do you have a zonal office at Kalachirpur?
Indeed, Your Lordship.
Then why did you register in Delhi?
Your Lordship, this particular matter in particular has been dealt with by itself in my argument. And when it comes to this particular matter, it should be noted that I would like to take reliance on Abhishek Banerjee, who is the Enforcement Directorate in this particular matter, wherein I have also given submitted a copy of the same, wherein page 20, it is mentioned, same line of argument had been erupted in that particular case as well. And in paragraph 20, the Honorable High Court of Delhi had clearly opined that when it comes to the territorial limitations that are imposed on the under the PMLA, which pertains to the organizational chart of zonal offices under the PMLA, that is not a statutory bar. And since it is not a statutory bar, the Honorable High Court of Delhi held that if there is any judicial transgression on this particular power or executive or administrative power, it would be a transgression of power, as I said. Hence, this is the reason. With this, concluding the facts of the present matter, on 2nd October 2023, Mr. Ashok was arrested under Section 19. And subsequently, the same day, summons were also issued under Section 50 to his sister. if your lordships are well versed with the facts of present matter, I would like my co-counsel to take over for issues 1 and issues 4. Much obliged. Lordship, you have the permission. Good morning, Lordship. I'm awaiting my importance and I have a permission here to submit the submission. Your Lordship, I'll be dealing with the issue of maintainability and the assets of petitioner and the movement of my arguments is as following. In respect of the first issue, I'll be considering section 19 clause 1 in order to determine the legal validity of the rest, and there is an issue over which on the second issue for the reason of to establish the procedure established by law has been followed. Furthermore, in respect of the second issue, I'll be considering section 17 clause 1 subclause 2 of the DMLA Act, as well as certain other provisions, along with the assistance of the judicial business that has been set by the sovereign court. Your Lordship, for the first issue, kindly see the 9th point of the proposition, where it is stated that the petitioner was arrested and the ground of such arrest were not informed orally. This is an advocate's stance. No, Your Lordship, I'll further explain that. The relevant provision of under PMLA Act is section 19 clause 1. Section 19 clause 1 mandates the requirement of apprehension behind such arrest, the reason to believe behind such arrest to be recorded in writing. However, it emphasizes the urgency of informing the grounds of arrest with the phases as soon as may be. It does not mention any manner how the grounds of arrest are to be informed. Your Lordship kindly refer to the case of Vijay Madanlal Chaudhary versus Union of India, which is mentioned in page 4 of our compendium, whereas it is stated that the oral communication of grounds of arrest would be adequate for complying with statutory mandate, where that is within 24 hours, that is being reasonable within 24 hours from the moment of arrest. Furthermore, it was also held in that case that unlike an FIR, the ECI report that is filed by the there is no compulsion on supplying that to the accused or the petitioner in this kind of petition.
Have you read the Pankaj Bansal case?
Your Lordship, yes, I have read.
What does Pankaj Bansal say about
Your Lordship,
notification of written ground of arrest?
Your Lordship, Pankaj Bansal had said that written grounds of arrest are to be supplied to the accused. However, I would like to point out one thing. That Vijay Madanlal case had 3 judgments, Pankaj Bansal had 2 judgments. Pankaj Bansal case.
On that ground, he has been released.
Yes, and similarly, Your Lordship, for Pankaj Bansal case was given on, I think, I believe, 3rd. Yes, on 3rd, and the arrest was done on 2nd. And this will be on prospective application of judgment.
And why will our judgment have prospective?
Your Lordship, judgment will have prospective effect because in case, let me give you an example in this current situation. Those accused who were punished and thereafter a similar later another judgment came which did not go in the same line of that judgment. We cannot go back and reduce that punishment. We cannot do such that.
Not violated fundamental right, those accused will.
Your Lordship, I'll be illustrating on that. I'll be illustrating on that whether fundamental rights are valid. Your Lordship. Furthermore, in
You have not provided them written ground of arrest.
yes, sir.
Pankaj Bansal says that written ground of arrest has to be provided.
By the same time, Your Lordship, yes,
Does it say so?
yes, Pankaj Bansal says.
It is otherwise right to know and duty to inform is a fundamental right.
Yes,
This right is derived from Article 21 itself.
yes, Your Lordship.
How can you ignore that?
Your Lordship, Pankaj Bansal suffers from the defect of per influence. It had 2 judgments. Vijay Madanlal had 3 judgments. So the 3 judgments decision would prevail.
What does Vijay Madanlal say?
Vijay Madanlal, I'll refer to the paragraph number as well.
Read the exact para. What does it say?
Yes, yes, Your Lordship. Vijay Madanlal says that yes, the ECI may contain details, paragraph number 415. The ECI may contain details of the material in possession of the authority and recording satisfaction of reason to believe that the person is guilty of money laundering offence if revealed before the inquiry or investigation required to proceed against the property being proceeds of crime, including to the person involved in the process or activity connected therewith, may have deleterious impact on the final outcome of the inquiry on the inquiry or investigation. So as long as the person has been informed about the grounds of his arrest, that is sufficient compliance outlined of Article 22 clause 1 of the Constitution.
Where does it say that it can be oral?
It does not.
Vijay Mandal law does not deal with oral and writing.
Hmm.
The only judgment that deal with oral and writing is Pankaj Bansal.
But your lordship, it has
Pankaj
prospective.
Bansal in unequivocal terms says that it has to be written.
Yes, your lordship,
Given
your lordship, at the same time, the ED officials were not aware on the second, the day before Pankaj Bansal judgment came.
What relief was given to Pankaj Bansal in that case?
Your lordship.
Did we release Pankaj Bansal?
Yes, yes, your lordship.
Was Pankaj Bansal arrested before that judgment?
Pankaj Bansal was arrested before the judgment. Yes, your lordship.
And we applied the Pankaj Bansal judgment to Pankaj Bansal while giving it relief.
Yes, your lordship. Your lordship has,
What is the doctrine of prospective overruling?
the doctrine of prospective overruling is when, after a judgment is given, another judgment is given, then, if it has a higher bench higher quorum, then that judgment would be given.
Is there a separate doctrine of prospective overruling?
Yes, it is.
But have you read the IC Golaknath case?
I agree, so yes, your lordship.
What does IC Golaknath say on prospective overruling?
The council is giving notice on that. Council is giving notice on that. Your lordship, for the vision, in respect of the Vijay Mandal case, I place my relax on the Ramkishan Arora CD case, which has been mentioned in page 4 of the complaint.
RK Arora binding on it.
Your lordship, I just. Your lordship, RK Arora has reaffirmed the view of Vijay Mandal case. Although it came before Pankaj Bansal case.
They have misinterpreted the Vijay Mandal case.
but the later judgment of Pankaj Bansal has to prevail.
Your lordship, at the same time, Pankaj Bansal suffers from the defect of foreign. It had a lesser quorum.
What is the doctrine of per interview?
When judgment is passed where lesser quorum and against the judgment of higher quorum, the judgment of higher quorum is supposed to prevail, and that is supposed to be the precedent.
But Vijay Mandal Chaudhary does not deal with the aspect of written or oral.
No, it is silent on it. It is silent on that.
How is Pankaj Bansal per interview?
Yes, your lordship. I specifically mentioned paragraph number 459. The line that does not mean that in every case the procedure must be followed. That is an admitted stance. It is enough if ED at the time of arrest contemporaneously discloses the ground of such arrest to person.
That doctrine of precedent does not militate against the principle of foreign kingdom.
Beg pardon, your lordship.
Doctrine of precedence
Yes,
does not militates against the principle of foreign kingdom. Because precedence means when a case actually decides it.
Yes.
It's a case actually not logical following is not a precedent.
Yes, your lordship.
Then how do you say that judgment is foreign kingdom?
Your lordship, precedence in this manner has been said because Vijay Mandal has
You
been
are talking
several
about
arguments.
this on the basis of logical following of that case.
Mhm.
Not on the basis, what was the exact question decided in that matter? Question of law.
Question of my lordship. And
Those points have not been discussed in the earlier.
Yes, if those points had not been dealt, if that particular question of law has not been dealt, then foreign currency will not be applicable.
your lordship, in the case of Vijay Mandal, the specific issue that was there, whether PML or
Vijay Mandal Chaudhary judgment with you.
I don't have the full judgment. I have specific paragraphs of that, and I just have the key facts.
There is a heading just above para 458. You
So
have the extent.
your lordship, the whole judgment is not.
The paras you are reading are only in context of distinguishing between ECIR and FIR.
Yes, your lordship, but at the same time,
It does not deal with ground offense.
your lordship, it is acting on the respect of ECI. ED is not acting on respect of FIR. ED is not a police officer. That issue will be dealt by my co-counsel. As ED is applying, acting on the basis of ECI, the rules of ECI will be applicable. At the same time, because Vijay Mandal Chaudhary case has specifically mentioned the contemporaneous disclosure of grounds of arrest will be enough. If at the time of arrest, that is available.
What does RK Arora says about the applicability of Pankaj?
We don't see that relevant paragraph is not present here.
That is the only para that helps you.
Your lordship, consequently. that I will take the very big option. You also apologize for the delays. You know, RK, Ramkishore Arora is.
You can proceed with the issue.
Yes, other issue.
You also have submitting with the issue of attachment of properties. Your Lordship kindly refers to section 17 clause 1 subclause 2 of the Penal Act, where the authorized officer is empowered to seize the property that is associated with proceeds of crime. The seized property and its assets are deemed.
When actually predicate offense occurred in this case? On which day?
The predicate offense had occurred as per the fact sheet on the date of Your Lordship, it was on 28th June 2021.
And when was this property acquired which you have attached?
That is on 23rd March 2020.
Whether this property can be said to be acquired from proceed of crime?
It cannot be said to be acquired from proceed of crime, but I
How have you attached this property? Which provision of law have you attached this property?
Your Lordship, I'll refer to the judgment of Directorate of Enforcement versus Axis Bank, page 24 of the complaint name, where it has said, I'll just read it as accelerated, that it was held in the circumstances where the tainted property cannot be located or accessed for any valid reasons, or is found to be deficient. The authorized enforcement officer may have the power to attach any other asset belonging to the individual accused of money laundering, provided that it possesses a value similar to that of the tainted property. Such property that is attached will be deemed as tainted property.
What does Vijay Madan Lal Chaudhary say about this?
Lord, should I refer to the judgment? Your Lordship, I believe Vijay Madan Lal Chaudhary had said that you have to deal with directly the property that is directly attached. Sorry, that is directly linked with the proceeds of crime.
So Vijay Madan Lal Chaudhary, Axis Bank, who money married is a judgment of Delhi High.
Yes, Your Lordship.
Vijay Madan Lal Chaudhary will apply.
Your Lordship, and in this case, the objective of
We'll go to the next week.
Your Lordship.
Yeah, great. Speaker is left, right?
Yeah, maybe Your Lordship. Your Lordship, issues to when the IIT dealing with issues, so my co-counsel dealt with my report. As far as my arguments or my roadmap for issues to my case are concerned, when I will deal with issue 2, that is pertaining to the arrest of Mr. Rito, I will be particularly, and since we have to talk about its validity in accordance with law, I will first be talking about how it is consistent with the PMLA, then how it is consistent with the provisions of the Constitution, and I will be supplementing both of these with provisions from the fact sheet or case law. Secondly, when I will talk about the issue of issuance of summons under section 15 to Mrs. Anita, a similar modus operandi will be followed. Wherein I will be first talking about the validity under PMLA, then the Constitution, supplemented by case law and para from the fact sheet. Your Lordship. Do I have permission to
On the mandatory or the
Your Lordship, maintainability was to be dealt with my co-counsel. Your Lordship.
What do you have to say?
what do you have?
Your Lordship, the current writ petition is not maintainable since, as Your Lordship also had pointed out, that alternate remedy exists in 126, and we have seen various cases. For example, the Gavin case, there are a lot of cases that have been dealt in which the petitioners have first approached the Supreme Court, and the Supreme Court itself has told them to first approach the remedy under 226.
Hemant Soren was based on a PIL. That decision was based on a PIL. We are talking of the recent human.
Indeed, Your Lordship.
That was the case of PIL. Public interest litigation was there, And then you have to follow the red rules first. Then you come to this spot.
Indeed, Your Lordship.
It is not a care.
Indeed, Your Lordship. My apologies, but there are
Not so there of the petition will be followed as the packet.
Indeed, Your Lordship. Let me cite to you certain other cases. For example, there was the Chanda Kochar case in the ICFAI case, which was a writ petition, which Chanda Kochar had approached Supreme Court itself, and the Supreme Court had told Chanda Kochar to approach High Court under 226 laws. There also exist similar examples along the same line. That is why in the opinion of the council,
So what is the difference between 6 and 30?
Your Lordship, when it comes to 226 and 32, one of the key differences is that under 226, writs can be obtained even based on constitutional rights and not just fundamental rights. Whereas when it comes to 32 only deals with violations and writs to be obtained on the violation of fundamental rights and not constitutional rights present in the constitution otherwise.
The which part of constitution apply?
Part 3, Your Lordship.
32 itself a fundamental right.
Indeed, Your Lordship.
How can we use to hear them when they are exercising a fundamental right?
Your Lordship, I would like to point out that there exists a difference between admissibility and maintainability at this particular juncture. By virtue of having a fundamental right, they can approach the Supreme Court, no doubt. And we have agreed that it's a statement of jurisdiction as well. But when it comes to application, when it comes to procedure and precedent that has been established by the Supreme Court, it must be seen that the case laws and histories of voluminous case laws have seen that 226 is approached first. And given the fact that there can also be pendency on the bench on the entire forum, that also
The personal liberty is in danger. Why they can straight away to the. They cannot straight away go to the.
Your Lordship, that is the correct point in law that you have stated that when the violation of personal liberty is there, then Supreme Court can be approached. But I believe my co-counsel also had in his submission that there is the violation is not such of such a grave nature that 32 should be invoked and the Supreme Court itself should should deal with it in the first place. May I proceed with my issue, Your Lordship? Much obliged. When it comes to my first question, which pertains to the arrest of Mr. Ashok, a bare reading of the PMLA Act under Section 19 Clause 1, it reveals certain necessities that must be complied. I will be talking about those necessities that pertain to the facts of the present matter, Your Lordship. Firstly, and in no particular order, when it comes to the provision of the grounds of arrest to the person who is being arrested, and as has been discussed with the opposite counsel and with the co-counsel as well, let me cite you another case law in which the grounds of arrest, as we have discussed already, let me cite you another case law, which is the case of state of Maharashtra versus Shobharam, which has been given in our written submission. State of Madhya Pradesh, my apologies, versus Shobharam. If you may please direct your attention on page 18 of our written submissions, and in the compendium it's given in clause 17, Your Lordship. That particular, the issue of state of Madhya Pradesh versus Shobharam clearly highlights that there is a mandate, specific mandate of Article 22 Clause 1. The mandate of Article 22 Clause 1 clearly highlights that the grounds of arrest should be reasonably communicated to the person who is being arrested. And it is my humble submission before the Honorable Court that in this particular, according to the facts of the present matter, particularly paragraph 9 of the Moot proposition clearly highlights that a reasonable communication had taken place by informing the person arrested orally of the grounds of arrest.
I think this issue has been dealt with your.
Your Lordship, indeed, he did deal with it, but it was just to establish that there exists no maintainability of the petition. That is what he wanted to deal with. Moving on, as you had also cited correctly, Your Lordship, that when it comes to the case of Pankaj Bansal was delivered on 3rd October 2023, and given the fact that it is not expressly retrospective in nature, and also combined with the fact that the arrest took place just a day before, and given the fact that it has no express retrospective applicability, then it is my humble
The
submission.
requirement of describing a retrospective applicability of a judgment.
I am sorry, Your Lordship.
Is that, are we required to apply a judgment retrospectively? Then only it will apply retrospectively.
No, Your Lordship, just as a general.
As a general rule, whether it will apply prospectively or retrospectively.
As a general rule, it will apply prospectively, Your Lordship.
Will apply prospectively.
As a general rule, a judgment would apply to all the points of law that it has find one after the deliverance of the judgment, Your Lordship.
If we are interpreting a law, how can it apply prospectively?
Your Lordship, as my co-counsel had also pointed out, if, for example, there is a case in which a certain bench opines upon a certain provision and people before the judgment have been guilty of a certain offence, but have been given a separate punishment. And if the bench in that particular point of time in the future opines that their punishments should be under that particular offence should be increased. As a general provision, those who have already been punished at that point of time would not be subject to what the new judgment is saying, Your Lordship.
So new judgment will not apply to all facts.
No, it's not that it will not apply to old facts. It will apply to all the cases that.
Actually, tell me this, when was Mr. Bansal arrested in this case?
Your Lordship. Your Lordship.
Arrested before this judgment,
Indeed, Your Lordship.
then only approached us.
Indeed, Your Lordship.
Then what was the relief given to Mr. Bansal in this case?
He was released from arrest, Your Lordship.
We never said that we are not applying it to Mr. Bansal, it will apply to other people. We applied it to facts that were there already.
Indeed, Your Lordship. As far as the operation or the operative part of Pankaj Bansal is concerned, as you had also pointed out, Your Lordship, that it contains the word henceforth, which implies that the points of law that it lays down.
Roop Bansal judgment of Punjab and Haryana High Court.
I'm sorry, Your Lordship.
Roop Bansal judgment of Punjab and Haryana
The
High Court.
council seeks it, Your Lordship. Your Lordship, I'm also when it comes to
What does RP Arora judgment say about applicability of Pankaj Bansal?
RPR judgment held that Pankaj Bansal was for imprisonment, and that when it comes to the written grounds of arrest, there is no provision of written grounds of arrest, even though the grounds of arrest must be communicated within 24 hours. That is what it had specifically laid down. Moving forward, Your Lordship, since I only have 30 seconds left, I seek your permission to move to my third issuance of summons. Much obliged, Your Lordship. When it comes to the issuance of summons under section 50 clause 2, Your Lordship, it must be highlighted very expressly. It must be highlighted that section 50 clause 2, a fair reading of section 50 clause 2 also further highlights the fact that any person can be summoned. Now I would like to place reliance on the PMLA itself under section 2, subclause 1, clause 1, subclause S, which defines the person itself, Your Lordship. When in the person, one of the criteria that is being one of the constituents of a person in the definition is an individual, and I believe it is among common prudence that a man or a woman both are included under the definition of an individual, Your Lordship. And then
prayer.
indeed, Your Lordship. Therefore, in the light of the submission made, issues raised, authorities cited, and arguments advanced, the Honorable Court may please adjudge A. That the present petition before the Honorable Court is not maintainable. B. That the arrest of Mr. Ashok was valid and constitutional. C. That the summons issued to Mrs. Anita was valid and constitutional as well. And 4. That the attachment of their properties and their bank accounts were valid, constitutional, and in accordance with the PMS Act of 2002, and or pass any other order or read in light of justice, equity, and good conscience that is Honorable Court may deem fit. For this, the counsel for the respondent shall complete speaking. Much obliged. It was an honor. I'm
Speaker 1 or 2?
Speaker 1.
Just speaker 1.
Much obliged.
Left out.
As both the teams have been completed with their arguments, then we can start with the rebuttals and serving rebuttals. Each team has to complete it within 5 minutes. So.
After the information from the officer,
Your Lordship, the council seeks permission to proceed with the rebuttals presented against the arguments of the respondent. Much obliged, Your Lordship. Your Lordships, the respondents in the present case have contended that procedure established by law cannot be taken as a ground for filing a writ petition before the Honorable Supreme Court. However, the petitioners in this case contend that the procedure established by law in the present case is Section 19 of PMLA, which specifically provides that reasons to believe must be recorded in writing before effecting an arrest, which is the procedure in the present case, Your Lordships. If the procedure in this case has been violated, a writ petition shall lie maintainable before the Honorable
But
Supreme
for
Court.
benefit, I may say that in the Hemant Soren matter, some litigation in the civil court was pending. And that is why he was directed to go before the High Court under Article 226 because of large number of civil proceedings were pending. And that is why, and then you have got a good case under Article 32 if the provisions of Article 39 of Section 19 has not been followed.
Indeed, Your Lordship, thank you so much for the insight. The Council seeks that because of the violation of Article 21 of the Constitution, the petition lies maintainable before the Honorable Supreme Court. Your Lordships, for issue 2, the grounds of arrest, the respondents have placed reliance on Ram Kishore Arora and as well as Vijay Madanlal. As has already been noticed by the Honorable Bench before, that Vijay Madanlal is in fact silent on the mode of communication of the grounds of arrest to the person being arrested, Your Lordship. In fact, the case that talks about the grounds of arrest and the mode of its communication is Pankaj Bansal, Your Lordship. Your Lordship could kindly take note of para 22, page number 22, paragraph 9 of the judgment, Your Lordship. And also, on recent Balaji, it has been noted that the grounds of arrest must be informed to the accused persons in writing. The respondents in this case, Your Lordship, argue that reason to believe it may not be supplied to the accused as it is a part of ICFAI and it is an internal document. However, Your Lordship, it is a constitutional safeguard under Article 22 of the Constitution of Ireland that an arrested person must be informed of the ground of his arrest at the time of his arrest itself. Since that could further hamper his ground when he files a petition for bail, an application for bail before the court during his trial. Your Lordships, the petitioners, the respondents also mentioned that there has been sufficient communication just because Mr. Ashok has been informed of the grounds of his arrest orally. However, the council here contends and also the respondents mentioned that Pankaj Bansal does not comply with Vijay Madanlal. However, Your Lordship, this is not the case in the present case. Pankaj Bansal is not a departure from Vijay Madanlal, however, a mere extension of it. Vijay Madanlal still provides, Your Lordships, paragraph 322 of the judgment of Vijay Madanlal provides that an accused person must be informed of the grounds of his arrest. And Pankaj Bansal further provides a substantial ground on that aspect that the communication must be made in writing. With respect to issue number 3, that is submission, the council here basically place reliance on Abhishek Banerjee, which may be brought to the notice of the Honorable Bench. It has been stayed by the Supreme Court.
Thank you. Thank you.
The council is permission to approve the motion for the Your Lordship, just three quick study points to be made. Firstly, Madam Council just now pointed out that the mandate of Article 19 provides for solution for grounds of arrest in writing. Whereas a very provision of Article 19 itself, nowhere mentions that written grounds of arrest must be provided. And I urge the Honorable Bench to think about that, Your Lordship. Secondly, Madam Council also cited the case. Your Lordship, if you give me 1 minute, I will Your worships, as the question that you had posed as to why is it not maintainable? If I remember correctly, when it comes to maintainability under Article 32, a lot of grounds are to be considered. Mainly, the reason that there should be a very grave and fundamental breach of personal justice, a personal violation of fundamental rights should have occurred. And that was a contention in our oral arguments that such a grave breach of justice is not occurred in the present matter, which is why the case under Article 32 weakens as far as maintainability is concerned. My last submission for the survey buttons, Your Lordship, is that in the oral arguments, Madam Counsel had mentioned that the facts clearly highlight that the EC has not provisioned any written ground of arrest, and therefore it violates the mandate of Article 19. When I had spoken about Article 19 and the necessary ingredients, I had particularly mentioned that I will stick to the facts of the case. Because it is not mentioned in the facts whether the written grounds were arrested or not. Therefore, none of the parties can assume or create any facts and conjecture, Your Lordship. That these were my humble submissions, and I would like to much obliged.
आपको मिल गया ना मोट इंटरनेट
I congratulate the team for reaching the finals and performing excellently. Two, we will be starting our valedictory ceremony for the 5th ICFAI National Moot Competition 2024. I thank Professor Dr. B. Acharya and Professor Dr. Arun Kumar Singh for adjudging our final round. We thank you for your time and valuable presence. With this, I request Professor Dr. Tapal Kumar Chandola, Dean, ICFAI Law School, and our faculty convener, Dr. Sunil Kumar, to join our esteemed judges. We are very honored to have the benign presence of our esteemed dignitaries today, who have not only adjudged the competition, but also enriched the minds of the audience. I would like to invite our Dean, Professor Dr. Tapal Kumar Chandola, to offer our heartfelt thanks to our esteemed guest on behalf of the ICFAI Law School.
Honorable Mr. Justice, Rajasthan and Honorable General Secretary, Mr. Babikar, Mr. Anush Tiwari, and all officers, all dignitaries of the dais, participants, and dear students. First of all, congratulations to all the participants that because of them, because of you all, this competition has grown and has come to this stage of successful implementation. I, on the behalf of the Honorable Chancellor in absentia, Registrar, and the entire committee, I welcome all the dignitaries on the days. And I will take the opportunity also to say that my presence has really meant a lot to all of us. It was very encouraging and very inspiring expression to this. And that has actually led to give the insightful and thoughtful meaning to this whole conversation. So, all the dignitaries, again, thank you very much for taking out time from your actually within the schedule. And we are all honored to have you all amongst us, with us rather. To the participants, I would say that the participation, as it is always said, and again, it is always true, that participation is the basis and the basic success. In the form of learning, in the form of one good step towards leading towards perfection in your life and specifically in your professional life. And therefore, again, I would say at the juncture that this national moot court competition was aiming to include the subject which in the current era, in the current time, is very much important, and it sought certain deliberations and the thought process of the participants also. And therefore, the compendium or the problem, the moot problem was designed in that way. So with these words, I would again say thank you to all present in this gathering. Thank you very much.
Thank you, sir, for your words. Now, I would like to request our special guest, Mr. Anush Tiwari, author and associate sponsor of the 5th ICFAI National Moot Court Competition, to impart words of encouragement and empowerment to our budget lawyers.
Mr. Justice Rajesh Tandon, my senior at the bar and Honorable Advocate General, Mr. S.N. Babulkar, Dr. Tapan Kumar, Dr. Monica Kajla, Dr. Sunil Kumar, Dr. Abhishek Ugreti, Dr. Acharya and Dr. Singh, Ashutosh, and all the volunteers that have relentlessly worked hard for this competition. I congratulate you all. And I only one thing to say, as the author of this Moot proposition, that justice was done to my proposition by both the teams. I don't know which team is going to get the title, because I was very confused, to be very honest. And of course, it is a matter that will be decided after calculating the score that has been given by all 5 of us. But to my mind, academically, both the teams have won. Whosoever takes the title, of course, there are different nuances that have been seen by us. But on the academic side, whatever was to be seen and whatever judgment I read to draft this proposition, all of that was in the compendium as well as the memorial that was presented to us. I congratulate you all, and I once again congratulate the volunteers. I was so overwhelmed by the hard work that they have done. And for that matter, the others may pardon me, but to my mind, it was volunteers event that has been organized today. I am very, very happy with whatever the volunteers have done. And for that matter, we are inspired also. Whatever we do in life, the small nuances that all the volunteers and students have taken care of. I am very overwhelmed. I congratulate you all and I thank you all.
Thank you so much, sir. Next up, I wholeheartedly welcome our esteemed guest of honor, Advocate General of Uttarakhand, S.N. Babulkar, sir, as a distinguished legal authority and representative of our state's esteemed legal system. Sir brings with him a broad spectrum of experience. Please join me in extending a warm and sincere invitation to convey words of wisdom.
Honorable Chief Guest, my brother, Justice Chandanji, the respected jury, my dear professors, my dear children and participants. I'm honored to be here. Although I had an urgent call from Nanita, but since Professor Chandola has told me to be here, therefore I'm here to record my presence. I'm very excited to see you, all of you. It was a wonderful presentation by you. My dear children, remember three things in our life. These are very important. Patience, perseverance, and precipitation. If you remember, if you proceed on these three virtues, then the sky is the limit of success. That's all. I again thank you for me calling that. Thank you.
Thank you so much, sir. It is my distinct honor and privilege to welcome our esteemed chief guest for today's event. Joining us is none other than Honorable Mr. Justice Rajesh Tandon, retired Uttarakhand High Court Judge, whose magnificent career has left an indelible mark on the legal landscape. With the knowledge, experience, and wisdom accumulated over years of service to the judiciary, Sir brings invaluable insights to our event. Please join me to request Sir to bless this occasion with knowledge and expertise.
Thank you, Master of Ceremonies. On the dais, Dr. Chalola, Professor Chalola ji, Professor Sunil Kumar ji, Dr. Professor Sunil Kumar ji. Our long relations brother, Sri Babulkar ji. We have got relationship from Allahabad High Court. And now he is Advocate General of Uttarakhand. Sri Ajay Kumar Singh and other co-associate all are present here. Today the topic that is chosen by the principals and students, although it's very alarming, but it gives a knowledge of so many acts. Just like the students have argued about the fundamental rights, that is part 3, Article 21 of the Constitution of India. Similarly, Article 22 also applies to the facts of the case, because the ground for arrest and detention has to be quoted. And further, the provisions of the CRPC are also applicable to the facts of the case as to whether if the compliance of Section 19 of the Money Laundering Act has not been done, then what will be the result? Whether it will be against the fundamental rights of Article 19, and he has a direct petition before the Supreme Court under Article 32 of the Constitution of India. or he has to travel to the High Court under Article 226 of the Constitution of India. Large number of cases are being decided on the basis of the money laundering and ED also. But in all these cases, the latest case, which was the students also are aware, and the team has also pointed out regarding the Pankaj Bansal's case. But at the same time, no decision has yet come where you can be deprived of approaching the Supreme Court directly under Article 32 of the Constitution of India. Even in the matter of Soran, the Chief Minister's matter, observation has been made by the Supreme Court, which I will just demonstrate before you, why he has been deprived to go directly to the Supreme Court. The Supreme Court has said that large number of cases are pending, civil cases are pending, and therefore it will be appropriate approach to the High Court. And he was a Chief Minister, and after the Chief Minister, he has to travel to the High Court. He cannot directly go to the Supreme Court. The Supreme Court has said, Soren promptly challenged the arrest in the Jharkhand High Court, with the hearing start from February 1 simultaneously. He approached the Supreme Court, challenging his arrest under the Prevention of Money Laundering Act. Senior advocate Kapil Sibal argued that the arrest raised critical questions about the application of Section 19 of the PMLA and questioned the manner in which Soren was taken into custody. He was assured that the top court parallel litigation before the High Court would be dropped. That is, parallel litigations are pending in the High Court, and therefore he has been ousted from the Article 32 of the Constitution of India. Therefore, students, you are right whether to approach Article 32 or to approach 226. That has yet to be decided by the Apex Court. And in the case of violation under the Part 3 and Section 19, that is a debatable question as to whether the direct writ petition before the Supreme Court will lie or not. That question has to be decided somewhere. But the Supreme Court in that is Pankaj case has stated a very few lines which will also weigh to you all the judgments and all the competitions and all everywhere you will be conferred with this power. The Supreme Court has said in Pankaj Bansal's case that where power is conferred to achieve a purpose, it has been repeatedly reiterated that the power must be exercised reasonable and in good faith to effectuate the purpose. And in this context, in good faith means for legitimate reasons. This word has been used by the Supreme Court in the Pankaj Bansal. That is legitimate reasons. You must have to give legitimate reasons. Where power is exercised for extraneous or irrelevant considerations or reasons, it is unquestionably a colorable exercise of power. Fraud on power and the exercise of power is vitiated. Malafide exercise of power does not imply any moral turpitude. It means exercise of statutory power for purposes foreign to those for which it is in law intended. It means conscious violation of the law to the prejudice of another, and that is why the Supreme Court has released this Pankaj Bansal, who was in the jail for the last several years. And therefore, we have to follow as to whether the real ingredients of section 19 has been complied with it or not. And that is judgment of the Pankaj Bansal, which was also demonstrated that will prevail over other judgments. In that context, Mr. Babulkar has to go early, and therefore I will not detain him much. In that context, I will use 4 lines of Osho has said about this legitimate expectation and about this how to act upon on section 19 of the Money Laundering Act. He has said, the sutra says, learn to look intelligently. By intelligently is meant by impartial. If you are partial, you cannot reach the heart. All partiality focuses you in the mind. Only an impartial consciousness comes to the heart. These are the words of Osho, and I think that is exactly applies to the ED also, to section 19 also, and all those investigations which are prevailing nowadays. Thank you very much.
Thank you so much, sir, for your work. We are pleased with your presence over here. Without any further delays, we'll move with the declaration of results, where we will recognize and celebrate the outstanding achievements of our participants. The 5th ICFAI National Moot Court Competition 2024 would not have been a success without the support and cooperation of our sponsors. I thank Anushtiari Law Offices for being our associate sponsor. Our exclusive knowledge partner, SEC Online. Our media partner, MyBlog. Our Gen AI partner, Concord. And our accommodation partner, Home in the City. Our event was provisionally registered by more than 32 teams, pan-India, following the final registration. The teams have been evaluated through prelims, quarters, and semi-finals. And finally, we have reached the final moment. For our final result, I request all of our judges to come before us and announce the winner and hand over the trophies and cash prizes.
Whatever you want.
The first award we are going to have is for the best memorial. And the award for best memorial goes to PC 21 HMM. Now, we have the award for best researcher. And the award for best researcher goes to CC3 Dhruv Bene from SLF Moot. Now, we have the award for Best Speaker. The award for Best Speaker goes to TC20 Speaker 1, Mohammed Sameer from Jamia Milli Islamia.
Yeah. Means not present. These are topics for you might not be expected. It would be surprised for this. Next.
Now for the final moment. Among TC2 and TC21, we are going to announce which is the winner of the 5th ICFAI National Moot Court Competition 2024.
Any guesses?
Audience,
21.
the award goes to TC21.
इसकी वजह से मिल रहा है अवार्ड।
The winner of the 5th ICFAI National Moot Court Competition with a cash prize worth ₹40,000. For our runner-up who have worked so hard and passionately to reach here, we are not going to let your efforts go waste. Please come up and receive your runner-up's trophy. Also, TC2, the runners-ups are from the Manipal University, Jaipur. All the winners are requested to kindly come up on the stage to have a group photograph.
With the trophy.
All the individual award winners also.
बेटा
आप जिधर आ जाओ।
Everyone kindly cheer for our winners.
God bless you all, and many congratulations to you all.
Thank you so much, all the judges, for gracing this event and making this occasion a success. I would like to request our faculty convener, Dr. Sudeep Kumar, to deliver vote of thanks and declare the competition as closed.
how will you do this?
The section is he was the registrar, but his current
Wonderful.
Thanks.
It was like neck to neck competition. And actually, we were genuinely confused. You both team did really great.
Your message, my friend.
Congratulations, both of the team.
Thank you, sir.
Settle down. Settle down. We can understand your venture. Thank you so much. A very warm good morning to our respected chief guest, Honorable Justice Rajesh Tandon, sir. Honorable guest of our honor, Mr. S.N. Babulkar Sahab, Dean sir, senior professors, and all my esteemed colleagues, participants of the competition, the dedicated committee members, and all my dear students. It is an honor and privilege for me to sit here to address this joyful gathering. First and foremost, I would like to express my heartfelt gratitude to the respected chief guest, Honorable Mr. Justice Rajesh Tandon sir, who have taken out precious time from his schedule to be present here and impart his knowledge and wisdom to us. Your Lordship, we are extremely delighted to have your benign presence at this occasion. I also extend profound sense of gratitude to have esteemed presence of honorable guest of honor, S.N. Babulkar sir, whose unparalleled expertise and incredible acumen has been insightful for everyone present here today. Sir, your presence has elevated the glory of this. I would like to express sincere gratitude to Mr. Anuj Tiwari for his invaluable support to National Moot Court competition. Your generous sponsorship cooperation has been instrumental in creating a platform for aspiring legal minds to showcase their talents and hone their skills. So your partnership has made a significant difference to everyone present here. We are deeply thankful for that and hope that this will continue in future also, sir. I thank Dean ILS, all the professors, faculty members for their invaluable, consistent support and affection, which culminated into successful inauguration and completion of this ceremony. I thank all the participants for showing enthusiasm for and being the part of this event and helping us to organize this event at national level, and also congratulate all the winners as well as participants for their competitive spirit. I admire the dedication, commitment, hard work of all the members of organizing committee, that is a Moot Court committee, who have worked day and night to make this event a grand success. I want to thank it was really a very joyous moment for me, particularly this moment, because this is the first event after Corona that we are organizing. And I know how difficult it was, because this this is the first time after Corona, because they have never organized any physical event before this. So this is the training for these people also. So very congratulations to my team. Once more, a huge applause for them. Last but not the least, I thank each and everyone present here from core of my heart. Once again, thank you.
Thank you so much, sir.
And with this, I declare this event as closed.
All our judges for making their presence over here. We are highly delighted by your presence. I request all the judges to kindly move towards the VC room for the lunch. Thank you so much. Follow request all the faculty members to accompany judges to the. All the winners